they'll just join in when they join in. And yeah, I want to encourage everyone who has questions as the seminar goes on to use the Q&A function at the bottom of your screen. So you can submit questions there, and we'll ferry them to either Michael or Rabbi Brown, whoever is more appropriate. And yeah, enjoy.
Excellent. Thank you so much to Nicole and to Marielle behind the scenes for organizing our webinar today. I want to welcome all of you from Temple Shalom, from near and far, to our topic today, which is on wills and estates. And we're very, very grateful to you, Michael, for joining us to offer some expertise on some of these important issues and things that we should all be thinking about. I'm going to start with a little bit of introduction and Jewish context, and then I will introduce Michael and invite him to share his presentation with us. So I know that we could say wills and estates and all of these things. What does this have to do with Judaism, besides that we want to we have so many Jewish lawyers, but that's a whole other topic. But really, this issue of thinking about our legacy, our future, what we are, how we are bequeathing our values and also our assets to the next generation is one that we've thought about as a people for a very long time. There's a lot just in Jewish law and the Talmud about all of the intricacies of how we do this. But what I want to just focus on in my introduction is the concept that I think is very, very moving within Judaism of not only creating directives from a legal standpoint, but also from an ethical standpoint. We have a tradition in Judaism of creating what we call an ethical will that is really very ancient. I mean, we see it a little bit in Torah, from Jacob giving words of blessing to his children before he dies. But we really have these beautiful letters that were written. We really see them starting in the Middle Ages of not just rabbis, but everyone creating these documents of their values that they wanted to make sure that their children and grandchildren would be able to inherit, to know what mattered to them, to understand their wishes about how they pray that they will live. And there's actually a lot of beautiful guidance out there right now of how to create an ethical will, and even using some technology, recordings, videos, etc. So if you're interested in learning more about that, please send me an email. I'd love to talk to you more about it. But for right now, we're here to learn about more of the tachlis, more of the details from Michael, especially in this time of COVID. I know a lot of people are thinking a lot about making sure their affairs are in order, and wanting to just discuss and try and think about what they need to do to get things in place. So again, Michael Scott, welcome. Michael is a wills and estates lawyer, and we're just really, really grateful that you're here with us. And I'll hand it over to you to share your presentation. Again, if you do have any questions, you can put them into the Q&A so that we can ask Michael. Thank you.
Thank you, Rabbi Brown. And thank you, Nicole Harris and the Temple Shalom team for inviting me to speak to you all. I put on a dress shirt for you today. So I can't say that I've been wearing one very often in the last couple of months. Full disclosure, I'm wearing sweatpants, but that's okay because this is a webinar. So I guess I'm a wills, estates, and trust lawyer. Just a little bit of background on me. I work with a firm at downtown Vancouver called Clark Wilson. It's a full service firm, but we've got an estates and trust group of about 15 lawyers, some of which work on the solicitor side, which is doing the estate planning and estate administration and trust and tax planning. And some work in the estate litigation side, which is more focused on where there are problems and finding ways to resolve those problems. So I'm not the most tech savvy, but I'm going to try to share my slides here if I can do this properly. think this is it. Oop. Okay, I think I've got this right. I hope everybody can hear me okay.
Looks good, Michael.
So here it is, the essentials for an effective estate plan. So with that, we'll talk about wills, powers of attorney, and representation agreements. I will talk to you about probate and probate planning, or different planning opportunities to get around probate. And through that, I'll talk a little bit about trusts and tax planning and how that kind of comes into play for estates. There are some pictures in my slides. So I'm sure that everybody here has their wills done, and if they don't, then they should consider having their wills done. And for those who do have their wills done, it would be wise to review them from time to time, and generally every 3 to 5 years. It's good just to have a look. It may be that you don't need to do anything, but it's good to just check to make sure that the person that you've got named as executor is the appropriate person to act, and your beneficial distributions are all the way that you want it to be, and yeah. Now, if someone dies without a will, then what happens is the Wills, Estates, and Succession Act in BC kicks in and determines how your estate is divided, and there's kind of a next of kin order to it, which for the most part goes to spouse and then to kids, and then to parents and grandparents and grandkids, siblings, and so on and so forth. And in addition to that, somebody needs to deal with your estate, and so somebody needs to step up and apply to the court to get the proper authority to deal with the estate. So it can be a little bit of a difficult process. In addition to making sure you've got your own wills in place, it's also good to ensure that if you have kids and they have kids of their own, that they're doing their own planning. If they've got young kids, then they should be appointing guardians in their wills. And they should also be establishing trusts within their wills to ensure that there is a vehicle to maintain the inheritance to their kids until they come of age. So, talking about wills, one of the first things that we look at with clients is who is the appropriate person to act as executor? Is there someone that you have that would be appropriate to manage the estate, to be the one to collect the assets, to apply for probate, pay out all your taxes and debts, and deal with the distributions the way that you've got it set up in your will? So those are the responsibilities that an executor has. It's a big job, so it can take a couple of years to administer an estate if it's straightforward, and oftentimes it will take longer than that. If there are difficult assets to deal with, or if there's litigation, then yeah, certainly it drags out the process. So for executors, I do get the question, is it appropriate to have a beneficiary also act as executor? And the answer is it really just depends on the circumstances. So if it's in situations where your beneficiaries don't get along, and if you have one of them named as executor, then the others may not like that, and it can cause problems. And so sometimes in those situations, people like to appoint someone that's independent. But if everybody gets along well and you've got someone that's appropriate to act and they're also a beneficiary, then that can be fine. And it's very, very normal for a beneficiary to also act as executor and carry out the estate. It's also important that the executor be a resident at least within Canada. So the residency of an estate for tax purposes is primarily based on the residency of the executor. So it's really based on where the control is really taking place, and the executor is the one that has control. And so if the executor lives in the States, for example, then your estate has become a non-resident estate for tax purposes. So in Canada. And so it doesn't necessarily mean that there are more taxes that are owing. It just means that there are more reporting obligations that the executor needs to undergo and withholdings in dealing with the estate. So it can add costs just through accounting fees and dealing with things. So ideally, an executor is a resident, where you are a resident, so where the assets are, but at very least, a resident within Canada. I mean, there are circumstances where the person that's most appropriate to act is not in Canada, and that's fine. They can certainly. I've acted for executors that lived outside of Canada, and we deal with the non-resident reporting, and that's okay if they're really the best person to act. But if there is someone that's available to act in Canada, then that would be ideal. So because it's a big job acting as an executor, an executor is entitled to take a fee. So they can claim up to a maximum of 5% of the gross value of the estate as a fee. And so that's what our legislation in BC says. Now, the way that the courts have interpreted that is to say that the 5% is really a maximum figure. So if the estate is very complex, the executor has had to put a lot of time and effort into the administration. They've been very diligent and skillful in terms of carrying out their duties. Then perhaps they'd be entitled to that higher fee. But otherwise, it's really a scale that goes down from there. So if the estate is more straightforward and doesn't take a lot of time to administer, then it could be more in the 2% to 3% range that an executor could claim. An executor could also claim nothing. So if they're also a beneficiary, and then they may claim nothing. And it's something that gets done through the process. So at some stage, the executor will have access or control of all the assets, and they'll be in a position where they're ready to make distributions from the estate. And at that time, they'll prepare an accounting, a report to show the beneficiaries, here are all the assets I've received. Here are all the expenses I've paid, all the taxes I've paid. Here's a reserve of funds that I'm going to hold to pay any further taxes and expenses as we go along, and which leaves this balance that I'll make for, I'm prepared to make for interim distributions. And here's what I'd like to claim as a fee. And if the beneficiaries get a chance to review that and consider if they'll consent to it, or if they do not consent to it. So there are checks and balances. An executor can't just take a fee. They have to run it through the beneficiaries. And if there's a disagreement, then it turns into a negotiation to kind of come to a happy medium for everybody. And if they can't agree, then if the executor feels very strongly about the claim that they're making for a fee, then the executor can apply to the court to have a registrar at the court review his or her executor remuneration claim and have the court give approval of it. So in addition to the 5% or that kind of one-time fee, there's also an annual management fee that an executor can claim. And so that more comes into play where there are ongoing trusts established within the will. So if there are reasons why the executor needs to continue to hold the estate for a period of time, then they can claim an annual fee of up to 0.4% on the average value of the assets every year for dealing with the management of those assets and on an ongoing basis. So every time that I'm meeting with clients to run through estate planning, we're also reviewing their tax planning and making sure that there's that their estate plan is going to blend well and be efficient from a tax perspective. So the primary taxes that we look at are so on the top of my slide there, it mentions the deemed disposition on death and capital gains. So how it works in Canada, when someone in Canada dies, it's deemed as if they've disposed of all of their assets as immediately prior to death. And so that disposition triggers any unrealized gains on assets. And that gain is then reported on that person's terminal tax return, which the executor would file, and the relevant taxes would be paid. So capital gains, it ends up being about 25% of the growth. So an example would be if someone had a recreational property that they've had for years and it was worth 500 grand when they received it. And then when they died, it was worth $1 million. And there's 500 grand in growth. And so about 25% of that would be taxable on death, which would be about 125 grand. So that's capital gains. Yeah.
Can I ask just a question that came up in our Q&A back to the executors, was about do you recommend that executors take a fee? How does that work in your experience? Is it beneficial to the estate or to the individuals?
So I have actually recommended an executor take a fee, but it's something that as the kind of professional advisor, when I'm acting for executors, it's something that I at least raise with them to say, look, you're entitled to a fee, and here's kind of my assessment of what I think you'd be entitled to claim based on the complexity of the estate and all the time spent. And some people decide to take a fee and some don't. And so it's really up to the person acting as executor to determine if they want to take a fee. Now that's on the when acting or when involved in an actual administration. But when we're involved in planning, so where we're setting people's wills up, I don't typically recommend to people to establish a fee up front that an executor can claim. And the reason that I wouldn't typically recommend someone do that on the front end is because it can be, you never know what the circumstances are going to be for the executor. So you don't know how complex it's going to be, or if there's going to be issues that have to be dealt with. And if you fix a fee, then the executor, I mean, if it's too low and it turns out to be too complicated, then it could deter the executor from acting. So they may decide, I don't want to act for this fee, so I'm just going to renounce and leave it for someone else to deal with. Or if it's too low, then if it's too high, then and it ended up being pretty simple, then the executors receive more than they should. So my preference, I mean, you might get people will get different advice from different lawyers on this, but my preference is to leave it open for an executor to determine what to claim.
Mm-hmm. Okay.
And then you've got the statutory limitation, which is the 5%.
Yeah. One other maybe quick executor question is about, can you have multiple executors? If someone has 2 children, can they both be executors, or is it better to have one?
You can certainly have 2 executors, and you could, and we certainly see that. So people will often have two executors appointed. Some of the challenges with that are that both executors need to agree and sign off on everything. So logistically, it can be a little bit more difficult because they both need to be present and attending meetings and signing and going to the banks and doing everything that they need to do. It can be easier for just one person to do that, but there are circumstances where it makes sense to have 2 act. More than 2, you can actually have more than 2, but then it gets really complicated. Now you've got 3 or 4 people all needing to sign off, and it just really drags out the process. And if there's disagreement, then it can cause issues as well. So if you have 2 or more executors and they're in a disagreement, now you've got a deadlock and the estate's not going anywhere.
Mm-hmm. Okay. One other little executor question, then we'll move on to taxes and other such things. Do you observe most executors to be family members?
Yes. So we do. So I think that the majority that I see are the kids. So if people have kids, then their kids are typically appointed. For people that don't have kids, sometimes we see siblings or nieces or nephews acting. Sometimes we see professionals acting. So often people will appoint trust companies to carry on the job, because it is a really big job, and it's becoming more and more complex, and people don't really want to put that burden on a family member that's really outside of their own children. And in those circumstances, we find that more and more people are appointing professional trust companies to take on these roles.
Great, thank you.
Okay, so into the taxes. So we talked about capital gains. In addition, we're always looking at probate fees and having that discussion when setting up estate plans to make sure that the estate's going to be as efficient as possible from a probate planning perspective. We're going to talk more about probate a little bit later on, but for now, probate fees are so the capital gains is a federal tax. Probate fees is a provincial tax, which is calculated at around 1.4% of the value of the estate. So $1 million estate would be 14 grand in probate fees, or 2 million would be 28 grand in probate fees. So it's a small tax in the greater scheme, but it's a tax that really goes up depending on the value of the estate. If you have a $5 million estate, then now you're looking at 70 to 80 grand in probate fees. And so as that number rises, then the value of probate planning rises with it to get around that tax and set things up to limit tax exposure there. So, and then outside of probate and capital gains, we've got just regular income taxes. So people that have income for the year that they pass, there'll be just their regular income tax. through employment, CPP, OAS, investments. In addition to that, there can be certain deemed income, so things like RSPs, RIFs, locked in, I think they're called locked income funds, and locked income retirement accounts, I think there are. So there's a bunch of accounts like that that are really taxable accounts. And so how those work really is, while alive, you can draw money out, and the money that you draw out is deemed as income for that tax year, but then on death, whatever is left in that account is treated as income. And so if you have a 500 grand in your RSPs, and that person passes away, then now that 500 grand is added to that person's income, which would be reported on their terminal tax return, and which would be filed by the executor and paid out of the estate. And so for 500 grand, there could be a lot of that might be taxed at the highest marginal tax rate, which would be around 50%. So that's something that we're looking at for planning, and just to try to minimize tax exposure and there.
Michael, I had another question come up about capital gains,
Yeah.
which is about when is the capital gains determined, from what date? So this person asked about, is it from the date of her marriage, the date of the death of her spouse? When does that clock start ticking for her own estate?
Okay, so that's so it's a good question, and it kind of, so yeah, it's there's not a super clear answer to it, but the very, at a basic level, the starting point would be once you have an interest in that asset. So if you buy a property, let's say you buy an investment property, then and you buy it for $1 million, then that's the starting point, is you own this property, it's worth $1 million. And then now going forward, the capital gains can be triggered in a number of different ways. So number one is it could be triggered on a sale of that asset. So if you sell the property, then any growth from the date of purchase to the date of sale would be triggered. Another way would be if that property is gifted to someone that is not a spouse. So to kids, if it's a recreational property and it's being gifted down to the kids, or to anyone for that matter that's not a spouse, then that would also be a disposition, and the capital gains would be triggered and would have to be paid on the next tax filing. And then, of course, the one that I mentioned, which is in the event of death. So on death, it's an automatic disposition, and the capital gain is due. Now, for spouses, we have in Canada spousal rollovers that can apply. So you can move assets between spouses on a rollover basis, which means that the asset there's no tax triggered. There's a deferral that applies. And so it just defers to between spouses. So if a spouse owns an asset and then they die, and then it goes to the surviving spouse, the taxes are deferred. The asset goes to the surviving spouse, and now the surviving spouse, the capital gains will be accruing for the surviving spouse going forward, and it's accruing from the initial purchase price that the first spouse had. So it doesn't reset based on the new value as of that date. They assume the capital.
Oops, I'm afraid Michael's a little bit frozen. Give it just a moment to catch up.
Gain.
There you are. You froze for a moment, but you're back.
Yeah, I noticed that. How long was I frozen there? Did people hear what I just said, or was the whole thing frozen out?
You were saying that it doesn't start over for, that the rollover happens, and the spouse, basically, it sounded like you were saying the spouse has the capital gains obligation of what their deceased spouse left from that.
Yes.
Okay.
Yes.
Yeah. So that's another kind of related question here about what if there was a divorce? Is there a capital gains concern?
So similar to kind of the spousal rollover, in the event of a divorce, their CRA will recognize, as you kind of go navigate that process of going through a separation, then assets that have appreciated value depending on who's ultimately going to receive that asset. So if there's a family, family home's not a good example, but if there's a recreational property and one spouse is going to be receiving that asset, then it can go to that spouse on a tax deferred basis. So there wouldn't be any taxes triggered unless the asset is sold. So if the asset is sold, then there's a different triggering of the capital gain, and that tax would be due and payable.
Okay. And then finally, one other related question. If you don't have a spouse, will the capital gains obligation roll over to a child?
So not, for the most part, the answer is no. So there's no rollover of capital gains to kids. There's only rollovers to spouses. So if you're passing an asset to a child, then you will pay that capital gain. So that it's triggered for you, and will be reported and declared on your tax return and paid out of your funds.
Great. So
there are to kids. I mean, if we're getting, I wasn't planning to get into too much detail about this, but there are certain exceptions to that rule. So for farmland, for example, so if you have a farming business, then farming businesses can be rolled down to kids on tax deferred basis. It can also be done for disabled children. So if someone has a disabled child and they have an RDSP set up, then certain assets can be moved into the RDSP on a rollover basis. How are we doing? Good questions. I'm glad. It sounds like people are engaged, which is it's great.
Here. Yeah. No, but go ahead and continue on.
Okay. I don't realize I don't have a clock, so if I'm starting to go too long, let me know, and I'll skip things or speed up. There's a lot of material. I'm trying to just touch on things fairly generally, and I mean, a lot of these things I could do hours on. So I'm trying to just to speak generally about a lot and go from there. So we talked about executors, we talked about taxes. Also, when doing wills, of course, we have to consider who are the beneficiaries going to be and how do you want to do the division. And when we're looking at that, when people have kids or spouses, we have to be mindful of, in BC, we have wills variation, which effectively means that if a child or a spouse feels that they've been inadequately provided for through the will, then that person can apply to the court to seek to have the will varied to give them a bigger share. And so a judge would review the situation and determine if it's appropriate to vary the will to give that child a larger share. So that comes up where people are looking to do an unequal division of their estate between their kids for whatever reason. There could be a number of reasons why people might do that, but when they're doing that, we're always looking at wills variation and considering, is this wills variation, is it going to be a real risk? And if it is, then perhaps we should look at some planning to limit that risk. And the other situation where it comes up is in blended families. And so what I mean by a blended family is where people have a second spouse or a third spouse where they have kids from a previous relationship. So that wills variation is only really applicable for biological and adopted children. It doesn't also apply for stepchildren. So where people are in a new relationship and they're starting to accumulate assets together with their new spouse, and they're taking ownership of those assets as joint owners, or they're naming each other on as beneficiaries of things like RSPs or RIFs or life insurance, then those assets will just go directly to the surviving spouse on death. So we'll talk more about joint tenancy, but effectively, when you own things jointly, then that asset that is owned jointly would on death of one will just roll to the survivor through a right of survivorship. And now the effect of that is those assets then would not go through the estate; they just go to the surviving spouse. And so if that deceased person has kids from a previous relationship, the surviving spouse has now received the assets outside of the will. The kids could make a wills variation claim, but there's no assets really to vary because those assets aren't part of the will. And now the kids have effectively been disinherited because they can't make a wills variation claim on that surviving spouse going forward, because there's no that right doesn't extend to stepchildren. So that's something that we're looking at, and in those circumstances, there's a lot of planning that needs to be done to ensure that everything is going to go the way that the will maker wants things to go, and oftentimes it's just a look at the assets to determine what's there and what's the appropriate split between the spouse and the kids. If the assets are for the most part tied up, then perhaps we'd look at things like spousal trusts and for that person to, instead of having things go directly to the surviving spouse, have it held in a trust for them for their benefit, and then ultimately pass to the kids on that surviving spouse's passing. Some people set up life insurance policies. So if they want most of their assets to go to their surviving spouse, but they want to provide to their kids as well, and they don't want to leave their kids high and dry, then people will set up life insurance policies and have the insurance policies go to the kids as a way of kind of balancing things for everybody. So the other situation that we need to be mindful of is if people have beneficiaries who have disability status. So if someone has a disability status and receives disability benefits from the province or the federal government, then we want to avoid having them receive an inheritance outright, because that inheritance will disqualify them from receiving those benefits going forward. And so instead, we have that inheritance go through a discretionary trust, and that will allow the beneficiary, the disabled beneficiary, to get the benefit of a certain level of income through the trust, while also maintaining their disability benefits. And then the other thing that comes up pretty much every planning session that I run through with clients is charitable giving. And here we are talking with Temple Shalom, and so it's very common for people to donate to charities, and Temple Shalom would be one, and people do that for different reasons. So some people do it for philanthropic reasons, and some people do it for tax planning. So giving to charity, of course, you get a donation receipt, which can be offset with taxes. And we talked about all the taxes that can be triggered on death. So it is something that often comes up as a means of limiting tax exposure on death by giving to charity to create an offset. Okay, so moving on, I'll talk to you about probate. We've touched on it a little bit. So probate, I'm sure many of you have probably had to deal with probate before in one way or the other, but I'll speak generally about it. What it is really is it's a court application that an executor has to make, or an administrator if there's no will, to seek the court certification that the will is a valid will and that the executor is the appropriate person to act. And probate is not always required. So it's only required if there's someone out there that requires the executor to probate the will. And so the common examples are if the deceased person owns real estate in BC, then the land title office will require the executor to obtain probate every time before they'd be willing to release title to the executor in order to deal with the property. Another example would be bank accounts. So if typically the banks will allow an executor access and control over bank accounts if they're lower values, so say under 20 grand or so. Although it's a policy thing with the bank, so it's not, don't quote me on the under 20 grand. I'm just kind of using that as an example. Because the lower amounts is just lower risk for the bank. So if they look at the situation and it's pretty low risk, there's a will, this is the person that's appointed as executor, they may be willing just to release those funds. But if there's more money in the accounts, then the risk, of course, goes up for the banks, and then they're more likely to require probate. So upwards of 40, 50 grand and beyond, they may well require that the executor go through probate. Now, in going through probate, the executor has to declare well, first has to determine what the assets are of that form part of the estate, and then has to declare those assets along with the values as of the person's date of death. And the overall value of the estate is what's subject to probate fees. So that's the amount that's subject to that 1.4% provincial tax. Now, if there's no will, I think I touched on it a little bit, but if there's no will, then of course nobody has any immediate authority to do anything. There's nobody that's been appointed as executor. So somebody from the family would need to step up and apply to the court to receive what's called a grant of administration. So it's very similar to a grant of probate, which is what an executor goes through in proving a will. But yeah, it's a grant of administration, but all the same protocols apply. So it's all the same checks and balances in terms of confirming for the court that it's a valid will, and same disclosure of all the assets, and same probate fees and everything.
One probate question came into us about a situation if someone dies outside of BC, which jurisdiction controls the probate?
It's a good question. So it's there's not, I guess, how do I put this? So you would there's not really a control element to it so much as it depends really where the assets are. So it would be, if someone, let's say, a common situation that we see are people that live in Alberta and have assets in BC, or vice versa. And so if somebody lives in Alberta, but they own a piece of real estate in BC, then they may have to go through probate in Alberta to deal with any assets that are in Alberta. And then what they do is they take that grant of probate they received from Alberta, and they would have to have it resealed in BC in order to deal with the property here. So there may be one will. It goes through probate in one particular jurisdiction, whichever is, the most appropriate to deal with first, which is typically the jurisdiction in which the deceased was domiciled, and then that grant needs to be resealed accordingly in any other jurisdiction where there are assets that need to be administered.
Great, thank you.
So we've talked about probate. We talked about probate fees. Now, in terms of how do we get around that probate fee? What do we do to bypass some of our taxes? There are a number of different ways that you can limit exposure to probate and probate fees, all of which need to be done with great caution. There are any steps taken to bypass probate can cause, although you may have avoided the 1.4% tax, you may have created other issues in its place. And so certainly I would, if looking to take steps to bypass probate, I would seek professional assistance and make sure that you're getting informed advice and making an informed decision before proceeding. Now, having said that, one mechanism that we use pretty commonly to get around probate are use of trusts. So stepping back for a second, probate applies to assets that form part of the estate. So anything that you own personally that goes through your estate is subject to probate and probate fees, and is also, for that matter, subject to will's variation because it goes through your will. So any variation of the will is going to impact the division of those assets that form part of your estate. Now, if you move assets outside of your estate and into a separate entity, then that asset now no longer forms part of your estate and is not subject to probate or probate fees. And so that's where the trusts come in, where people have assets that have value, that where the probate fees are going to be high, then they may consider setting up something like an alter ego or a joint partner trust. And then once that trust is set up, they can take their certain assets and move them from their personal ownership into the trust. And once in the trust can be set up in a way where the person maintains full control as trustee of the trust, and they would also be the primary beneficiary during their lifetime. And then they could establish provision in terms of what happens with those assets on death. So similar to a will. So you can really put all that language within a trust and have your assets administered through the trust rather than through your estate. The catch with these alter ego and joint partner trusts is that the individual, or individuals for that matter, if it's a couple, they need to be over 65 to do it. And there's special tax treatment for these trusts. So we've talked about capital gains in particular, and how it can be triggered. So on a transfer, a disposition of the asset, capital gains would be triggered. But for these types of trusts, the assets can be transferred to the trust on a tax deferred basis. So so the asset gets moved into the trust, no taxes triggered, they're deferred, and then would still just be triggered on a sale or on death. So once you've moved assets into the trust, those assets have effectively bypassed probate and probate fees, and have also bypassed any risk of wills variation. So those are the common reasons we see people set these up, is to if they have high value assets that can be moved into something like a trust, and to get around the probate, and also to if there's any risk of wills variation, then they've got that tool available. Some of the downsides with these types of trusts are that they're expensive to set up. So it could be anywhere from $5,000 to $10,000 to set up a trust like this, and it can be more if it's more comprehensive or more complex. And so you really need to balance the cost with the benefits. And so if if you've got $5 million in assets, and where the probate fees are going to be 70 to 80 grand, and it's only going to cost 10 grand to set it up, then that's good value. But if there's $1 million that you can move into the trust, where you're paying 10 grand and ultimately just saving 14, then that's not as good value, and may not be appropriate unless there's a high risk of wills variation. Then maybe it would still make sense to do it. I have a note here about family trusts, but sorry, go ahead.
Oh, just a question that just came in about trusts is, are there ongoing fees with trusts?
So yes, so there aren't typically ongoing legal fees. So the legal fees would typically just be in the setup, but there are ongoing accounting fees. So it's a separate entity, a trust. So it has to file annual tax returns, and so there'd be accounting fees for that. So it could be $1,000 a year or $1,500 a year to deal with the tax filings.
Okay. And one other question that just came in is, can a joint asset, like a bank account, with the right of survivorship avoid probate and their fees?
So the answer is yes. So owning an asset as so if you put actually, you know what, we're just about to get into that. So that's next talk. I think that's actually the very next slide.
Good.
I'm not going to talk too much about family trusts. Is there anybody else? Any other questions?
I think we can move on from there. And just to give you, we've got about 15 minutes left in the.
Okay, we're getting there. So I'm going to skip family trust, but it's just another way that people can use family trust. People will use family trust when they have business assets or companies, and they can roll their shares into a family trust, and that's another way of getting around probate. Okay, so right on with that question. So the other way to get around probate is the use of joint ownership or joint tenancy. Spouses use this all the time, and I would typically recommend to spouses to use this, especially if it's not a blended family. If it's the spouses that have the same kids, then owning, for example, your residence as joint tenants, the effect of that would be that if one of them dies, the property will automatically transfer to the survivor through right of survivorship outside of the estate and outside of the will. And then on that survivor's death, then the property goes through probate and goes through the estate. Same thing for bank accounts, investment accounts. Owning them jointly will allow them to pass to the surviving joint owner. Now, it gets more complicated when considering adding, rather than just for spouses, adding kids on as joint account holders or joint tenants to property. It's a question that comes up very regularly, and there are rare circumstances where it makes sense to do it. But some of the challenges are, I'll give you kind of an example scenario. So if you've got someone, if you have, so parent has a couple of kids, they want to put one of the kids on title as a joint owner because they were told that it would make sense it will bypass probate, then that may well be, but effectively that's your principal residence, the parent's principal residence. So as a principal residence, it's exempt from capital gains tax. And now the child who's been put on the ownership that now has an interest in the property, it may not be that child's principal residence. So now for that interest, there'll be capital gains that will begin to accrue, which is a bad result when it would otherwise be exempt for the whole property. So there's that child, if they have a spouse, and then they subsequently split up, that interest in the property that they have may be subject to matrimonial claims or an interest, or certainly part of the growth of it. So that's another reason or a thing that we're looking at, and also that child, if they run their own business or they get sued, and there's a judgment against them, then that creditor may search title to find that child has an interest in a property and register that judgment against the title, and now that property is encumbered, and so you've lost some control over what you can do with it. So these are things that we're looking at when putting kids on title. So there, in certain circumstances, it might make sense. If you have one child and they live in the property with you, and so it's both of your principal residents, and the person has a low risk job where they're not likely to get sued, then maybe it would make sense to add them as a joint tenant rather than paying all the cost to set up something like a alter ego or a joint partner trust. I won't talk too much about resulting trust, but effectively I will say, so when putting a child on as a joint owner to any asset, that parent-to-child relationship, it's actually presumed when the parent dies that the asset that is now in the hands of the child is held by that child in trust for the estate, unless there's a contrary intention that says that it was intended to be a true right of survivorship. So we have to be mindful of that as well. And when we're having these conversations with clients, we're always making sure to document, if there are joint assets, we want to document them cleanly to ensure that it's very clear what the intentions were of the parent in that circumstance. So joint ownership is one. It is a tool that can be used. It's most commonly used with spouses to get around probate. Lifetime gifts, so you can always give things away during lifetime. That would bypass probate because now you've given up your assets where you don't own them anymore, and you have to be mindful of your needs. You also have to be mindful of same things as we talked about with joint ownership, things like creditor claims and matrimonial claims, because if you're gifting assets, then any growth, they may be intermingled into family assets with their spouse, and then on a subsequent breakup, it can be difficult to claw that back and to ensure that your child is the one that receives that. But there are ways to deal with that, and normally we set these up as loans rather than gifts, which are just repayable on demand, and there are different ways to do it. And gifts are actually protected in matrimonial circumstances as well, but it's really just the growth that's subject to claims, or if they get intermingled in other assets where it gets tricky. The other common tool to bypass probate is use of beneficial designations. So things like RSPs, TFSAs, life insurance. You can name people as direct beneficiaries on those accounts. So then those accounts would go directly to those individuals. And we have to be mindful of the taxes. We talked about the high income tax applicable in particular to RSPs and RIFs. If there's a lot of money in there, then what happens is if you have 500 grand in a RIF and you name one of your kids as a beneficiary, then that 500 grand on death would go to that child. But the income taxes that are owing as a result of those funds are still owing by your estate. So that 200 grand or so in income tax that's applicable to those funds needs to be paid by your estate. So you need to ensure that there be money still within your estate to cover that tax liability, so that your executor has some access to funds to do that.
One just quick question, Michael, that came up about joint is, I guess, a terminology question. Is joint tenancy the same as joint ownership, or is there a distinction there?
It's really the same. So it's the same. It's called joint tenancy. Legally, it's called joint tenancy. But people use the word joint for ownership we say joint tenancy for real estate in particular, but bank accounts, they don't typically name you as a joint tenant on a bank account. You're just called a joint account holder, but it's effectively the same thing for legal purposes. The same rules apply with the right of survivorship and the resulting trust if it's a kid on there. Any other questions before I move on to powers of attorney? We're getting close. I think we're gonna make it in time.
I think yeah, keep going.
Okay, so we talked about wills, trusts, probate planning. That's really those are really things that are more, in the event of death planning. Now, these powers of attorney and representation agreements are really more in while I'm alive, here's who I want to appoint as the person to manage my financial affairs. So that would be a power of attorney. And here's who I want to appoint as the person to manage my healthcare and decision making, which is a representative under a representation agreement. So for powers of attorney, you got to consider who's appropriate to act as attorney. Do you have kids or a spouse that would be appropriate? Or if not, do you have nieces, nephews, siblings? If not, then you may look to trust companies to act in these roles. There are different ways to set these up. So you could do an enduring power of attorney, which would be, it would be effective immediately. So while you're capable, and then it would continue to apply if you ever became incapable. That's the most common way that we see these set up. There are often situations that come up where you may be capable and it may be good to have a power of attorney that has authority for you. For example, people that are retired and travel regularly, they may want to have someone that has authority, even though they're capable. They have someone in town that has the proper authority to deal with their affairs and can go and sign things with the bank or otherwise. A springing power of attorney is really, it springs into effect upon incapacity or another triggering event. The common one is incapacity. So in that circumstance, you'd set it up today, but then it's not effective unless you become incapable, and that's determined typically through an assessment by a physician confirming that the person is not of sound mind. So a power of attorney, the person acting as attorney would, in terms of their duties, so they would manage all your financial affairs, make sure your investments are in order, deal with your taxes, make sure your taxes are filed and paid, deal with your bills, anything financial related, they're doing that. There are some limitations. So a power of attorney cannot gift or make loans. They can, but it's the limit in our legislation is about $5,000 a year. So that can be a pretty low amount. So if this is something that comes up in planning, so when I'm talking to clients about powers of attorney, I'm getting a feel for, okay, do they donate, for example, regularly to charity? Do they make annual donations? If so, how much? If that amount is over that $5,000 limit, perhaps we should include some language within the power of attorney document to ensure that the attorney has the proper authority to continue with those donations annually, even in the event of that person's incapacity. So an executor doesn't typically get paid to do the job unless you expressly state that they can in the power of attorney document. So if you, when it's a family member or a non-professional, typically executors don't get paid. Where it's a professional acting, like a trust company, for example, then they'll have a fee agreement and they'll be paid. And typically they have a percentage of that they would charge, which might be around 1 to 2% of the value of the estate per year for kind of carrying out the role. Now, what if you lose capacity before putting in place a power of attorney document? In that circumstance, if you don't have, if you become incapable and you don't have a power of attorney in place, then unfortunately you now cannot put a power of attorney in place because you need to be of sound mind to do so. So somebody within the family would need to step up and apply to the court to become appointed as the adult guardian, so to speak. It's called committeeship. And it's a complicated court application. The public guardian and trustee gets involved and needs to sign off effectively on the person applying. And the person in question needs to be assessed by 2 different physicians and confirmed to be incapable. And so it's really it's a public process, and it can be a little bit ugly because it formally declares the person to be incompetent, which a lot of people don't want to do for their loved ones. Okay, so we talked about so representation agreements. I mentioned it's really a healthcare document appointing someone to make healthcare decisions. Again, you got to choose who's the appropriate person to act to make these decisions. These documents often have lots of language to them about life support and how pulling the plug, so to speak. There are different types. So we've got a Section 7 versus a Section 9. Those are just the sections within the Representation Agreement Act that kind of give different options for the setup of a representation agreement. A Section 9 representation agreement is really a full-fledged document which gives your representative full authority to do anything healthcare medical related for you. And it's something that you need to be of sound mind, have full capacity to enter into. A Section 7 representation agreement is one that is in place to allow people that have diminished or limited capacity to still be able to appoint someone as a healthcare representative, but there's different rules that apply for that, the representative acting. And yeah, so it's very rare that a representative dealing with healthcare would be paid to take on the role. I've seen it one time in my career. So it doesn't happen very often, but they can be paid. So the legislation does have some provision for a representative to be compensated, but it's not normal. Only in certain circumstances would it come up. Similar to the power of attorney, if you don't have one of these documents in place and then become incapable, then somebody needs to apply to the court to be appointed through committeeship to make those decisions. And it's the same application as with appointing someone on the financial side. So typically, it's something that gets done. If someone doesn't have a power of attorney or a representation agreement, then they would do that committeeship application for both roles on one go.
Great. I'm just noticing we have a few minutes left and a few questions that have come in. Would you like me to ask them now, or do you want to
Sure.
kind of finish off your presentation? Either way, either order, if you don't mind. So two questions that are related that have come in are about basically kind of the fees and expenses to setting up all of these wills and powers of attorney, etc. One was about a situation where they've had a will set up, but back from maybe 10, 15 years ago, but now their children have children and they need to update addresses and beneficiaries and things like that. So what's kind of the least expensive way to do those changes? And then the other is about just setting these things up from the beginning, that they involve a lot of legal fees, and what's the best way for people who are on a fixed income, for example, to make sure that they have these things in place.
Okay, so for the first part, the most cost-effective way to deal with changes to wills and an estate plan would be just to go back to the professional advisor that you worked with initially, because they would have your documents, and if it could be that it's just a simple change where they can take the document and just make the simple change and get you to re-sign. And they may not charge you full cost to redo your wills altogether. Now, if you don't have documents in place and you're really just doing this for the first time, I mean, notaries do this type of work. It's they have limitations in terms of what they can do, so they would charge less, notaries, but they are limited in terms of what they can do. So notaries can't do trusts for the most part. They can't provide legal advice. Really, I think what they can do is just give you some general advice and give you kind of a very basic, straightforward couple-page will and powers of attorney and representation agreements. Now, what I can say is what I see a lot is people may have wills from 20 years ago, where it may be that there's only a couple little things that need to be changed. But because the laws and the tax rules have changed so much in the last 10 to 20 years, there can be other things, just general things that need to be added or changed within the will. So it could be that for older wills, you may want to do a full overhaul anyways to just bring it up to date with our current rules and regulations. And same goes for powers of attorney and representation agreements as well. And then you had another, so that was one, and there's another question.
One other question that came in, which is asking if you have any thoughts about what changes to the tax code the government might be making with kind of the added expenses due to COVID and the different programs, thinking about estate taxes, inheritance tax, things like that.
Oh, I have no idea. So what I can say is I haven't heard anything. So our estates and trust group are very active, and there's a couple of people in our office in particular who are very involved with legislative change. And so I get to hear it on a weekly basis in terms of what's going on. And I haven't heard any rumors that they're going to up any of these taxes. I mean, there have been the federal government in their annual budget have, a couple of times raised the idea of increasing capital gains tax, but then have not gone through with it. So those things come up from time to time. And then what happens for me is I get a whole bunch of phone calls from people saying that they want to trigger their capital gains now so that they pay it at a lower amount. And then all of a sudden, and then we talk to them about it, but then all of a sudden, the government doesn't go through with the change, and so then everybody backs off. So those things happen, but I don't know. I haven't heard any rumors that probate fees are going up. I haven't heard anything like that. So I think as far as we know, the rules are the way that they are, and they'll maintain how they are right for now.
Fantastic. Well, Michael, you gave us so much information in such a short period of time. I really am just in awe and grateful to you for all of that insight. I don't know if you have a last word or anything you want to conclude with.
Well, yeah, that was. I mean, I'm actually surprised that we got through that in an hour. That's great. If people have questions that they don't want to raise here, you're welcome to email me or call me. I'm happy to chat with you if you have specific questions of things that have come up, and I'll try to guide you as best I can and answer as best I can. I think that's really it. I mean, yes, there was a broad kind of presentation on a number of topics, and really just touching very generally on a lot of those. But so keep that in mind, if you want more information, then I mean, certainly I would recommend talking to your professional advisors, or you're welcome to call me, and I'm happy to have a chat with you as well.
Wonderful. Thank you so much. And thank you to Nicole and Mariel behind the scenes for making all of this happen. Just a reminder, this series that we've been doing over the past few weeks, we have one more coming up this week, just on Friday. We're looking forward to hearing from Jody Wilson-Raybould about our federal government's response to COVID-19. So that will be on Friday at 1. There's more information at the Temple Shalom website and to register for the link to learn more. So thank you, everyone. Stay safe, and we'll see you soon. Take care. Bye.